And I'm going to talk about love and relationships, not in the context of prairie voles, as we heard this morning, or in terms of extrapolating for the future, love and relationships with your household robot. No, I'm going to talk instead about marriage equality for gay and lesbian couples and the law and how the law has developed with respect to those relationships in the context of what we consider to be a family. First, let me just start off with three observations. First, the law has always evolved over time in response to changes in society and in our understanding of what is just and fair under the law. Second, during the past several years, several decades actually, how we as Americans and as a people and as a nation view both the nature of family and the nature of marriage has prompted important changes in family law. And somehow I get the feeling with this under 25 crowd, I'm probably going to be speaking to the choir in many senses. Third, although many of those legal changes have come through legislation and through popular vote, much of that change has come from the courts. From my perspective, having served on 4 different courts for 25 years, I see the court's role in those family law changes as both healthy and indispensable. Indeed, the necessity of evolution in the law and the importance of the court's role in that evolution is manifest. Now, it doesn't take much of a reminder that the original Constitution regarded blacks or African Americans as only 3/5 of a person. That slavery, which tore families apart, wasn't abolished until almost 100 years after our American founders declared that all men are created equal. And it took a civil war to do that. Nor will many in this room forget, in fact, Ruben Diaz has reminded us, that women had few rights and in marriage were regarded as akin to property when the Republic was founded, and that women did not get the right to vote until the ratification of the 19th Amendment in 1920. Folks, less than 100 years ago. Now, a mere 65 years ago, now I know 65 years is not a long time for me, but for you it's probably talking about your grandparents. But a mere 65 years ago in my state of California, it was not self-evident in constitutional or in statutory terms that a white woman could marry an African-American man. Because in 1948, California law prohibited a white person from marrying a Negro, mulatto, Mongolian, or member of the Malay race. Now, I found out about this, I guess I was about 21 in a bar, and I asked Ray, who was Filipino, how long he and his wife had been married, and she was Caucasian. He told me the number of years. I said, where did you get married? He said, we got married in Yuma, Arizona. He said, well, why did you do that? Why would you go to Arizona to get married? Because he said, we couldn't get married in California. Now, in an important case decided in California, a white woman named Andrea Perez and an African-American man named Sylvester Davis were denied a marriage license when they applied for one at the county clerk's office, and they claimed that the law violated their right to religious freedom, because they were Roman Catholic and their church did not prohibit interracial marriage. Of course, the church has taken a different position with respect to gay marriage. Now, a closely divided California Supreme Court at that time struck down that law, holding that it violated the Equal Protection Clause of the U.S. Constitution by impairing the right of individuals to marry on the basis of race alone, and by arbitrarily and unreasonably discriminating against certain racial groups. This decision in Perez versus Sharp recognized at that time that discrimination could not be justified by the fact that it had been sanctioned by the state for many years. In fact, many other states at the time had laws on the books prohibiting interracial marriage. Now, I remind you that it took almost 20 years until 1967 before the U.S. Supreme Court came to the same conclusion in a case called Loving versus Virginia. at a time when 16 states, this is in 1967, still barred interracial marriage. Now, I wonder how many of you know that the Lovings, and isn't that an ironic name for a case about marriage? The Lovings were criminally prosecuted and convicted for violating Virginia's anti-miscegenation law. And this is the astounding part of that case, as part of their state-imposed punishment, they were actually barred from living in Virginia as a condition of their probation. That is, they were banned. Now let's turn to more recent events in the law's evolution regarding marriage and how it relates to the family. In 2005, as a precursor to sanctioning same-sex marriage in California later in 2008, the California Supreme Court had a series of cases dealing with advances in reproductive technology and the custody of non-biological parents. There's a whole topic there that one could get into. And there were also other cases about same-sex parent adoptions of children. Now, in one of those cases, dealing with a birth mother and her lesbian life partner, I authored the court's opinion stating, and I wish I had a slide for this. My quote was, "We see no reason why both parents of a child cannot both be women." I was walking in the streets of San Francisco that evening, and when you're quoted in the San Francisco Chronicle above the fold, that's something to behold. Those are my words. 3 years later, in a 4-3 decision, we addressed whether the California Constitution could tolerate a situation where same-sex couples could enjoy virtually all of the substantive legal rights enjoyed by heterosexual couples, with one significant exception. Their officially recognized relationship was called a domestic partnership and not a marriage. In short, the court was asked whether separate but almost equal was good enough to pass muster under the California Constitution. Although later reversed in part by Proposition 8, more later about that, our 4-3 majority decision held that not permitting same-sex couples to marry denied them equal protection of the law. Now, several factors led us to that conclusion. First, denying same-sex couples the right to marry clearly is not necessary in order to afford full protection to all of the rights and benefits enjoyed by married opposite-sex couples. Second, such a denial imposes an appreciable harm on same-sex couples and their children because it robs them of the dignity and it robs them of the stature equal to that of opposite-sex couples. I remember talking to our Chief Justice in connection with our deliberations, and I said, you know, if we don't grant this term of marriage to these unions, they will always be considered second-class citizens. Finally, we noted that denying same-sex couples the same status as heterosexual couples perpetuates the premise that gay individuals and same-sex couples are second-class citizens who may, under the law, be treated less favorably than opposite-sex couples. Now, this holding that same-sex couples must be permitted to marry was short-lived because only 170 days after we issued our ruling, the California voters, through the initiative process, passed Proposition 8, a California Constitution provision stating that only marriage between a man and a woman is valid or recognized in California, and that passed by a very slim majority. Ironically, that same day that the voters approved Proposition 8 by a slim majority, another proposition passed regulating the confinement of chickens in coops. And I think you saw Nat Turner in one of his screens. There was a host of chickens in a coop. That initiative provided that egg-laying hens must be able to fully spread both wings, turn around, without touching the sides of an enclosure or touching other egg-laying hens. As our then Chief Justice later noted, chickens gained valuable rights in California the same day that gay men and women lost them. In 2009, following year, when our court considered the validity of Proposition 8, a 6-to-1 majority held that even if regrettable, Proposition 8 was a permissible exercise of the people's right to modify the Constitution. I dissented. I had to dissent because I believe that Proposition 8 was more than just a mere amendment to the Constitution, but a wholesale fundamental revision requiring much more than a simple majority vote. In my view, Proposition 8 was a change to one of the core values upon which our state constitution is founded. And as I wrote in my dissent, and I wish I could put this in rap the way Reuben did. I mean, I really do. Even a narrow and limited exception to the promise of full equality strikes at the core of and thus fundamentally alters the guarantee of equal treatment. Promising equal treatment to some is fundamentally different from promising equal treatment to all. Promising treatment that is almost equal, is fundamentally different from ensuring truly equal treatment. Thus, to me, Proposition 8 was a drastic revision and not a simple amendment to our Constitution. Such a fundamental change in the meaning of equal protection, to the promise of equality, to the right to marry, which is fundamental, to the protection of family rights and the right to privacy, indeed, to the very concept of liberty itself under our Constitution. All this could not be accomplished, if at all, by a simple majority vote of the voters. None of my colleagues joined with me in that view. None of them. And now the substance of that case, the validity of Proposition 8 under our federal Constitution, is before the U.S. Supreme Court. They argued that case, as you know, on March 26 last month. So you stand today at the crossroads of history on this issue. Certainly the civil rights issue of this generation, the millennium generation, I consider it to be part of my generation. Thus, 65 years after California broadened the definition of marriage to include marriage between people of different races, Proposition 8 has narrowed the definition to exclude marriage between people of the same sex. I still see no reason in law, no reason in equity, not to recognize marriage equality for gays and lesbians, because marriage is a fundamental right. Freedom of association is a fundamental right, as is the right to privacy. And I reject so-called traditional notions of marriage because if history has taught us anything, it's that tradition becomes self-justifying, and that if we fail to acknowledge social progress and the full entitlement of human and civil rights, we would still have certain forms of servitude, denial of property rights and other rights for women, and a prohibition of interracial marriage, among many, many other rights. On the question of what is family, we've seen the many forms that takes, blended families and so forth. I myself come from what would be called a fractionalized family, I suppose. But at bottom, what is really essential, and I think you would all agree, whether we're talking about voles or robots or whatever, is a loving, committed family. A family that nourishes and welcomes the too many children who need loving homes. Over 110,000 children adopted by gay and lesbian couples in the United States, with just over 40,000 in my own state of California. And let's not forget, I don't know if someone said this morning, that our families, your families, includes everyone of whatever sexual orientation. There are sons and daughters, our aunts and uncles, our nephews and nieces, not to mention our workplace families where we spend a good part of each day. And I've always been baffled, really, by claims that same-sex marriage will have deleterious effects on opposite-sex marriages. My own, for example, of 29 years. I just don't get it. I just don't get it. This institution of marriage is a good thing. That's why gay people want it too. To share the same joy and happiness, but also to share the same obligations, responsibilities, and burdens that so many of us in married life have endured. This is actually a good thing for the institution of marriage, not something that demeans it or cheapens it in any way. And if it were only about a word, the M word, why the fuss? Because as we know from Lynn's talk this morning, words have meaning. Words have meaning. They impart a sense of worth and respect and a sense of dignity. Or they also convey the opposite, words that tend to demean. And I recall the words, the argument of a lawyer arguing the marriage cases in our court about the M word. And he said, well, let's reverse the terminology. If this is no big deal, the M word, let's call all heterosexual unions civil unions. And let's call gay and lesbian unions marriage. Let's switch things. Would anyone complain about that? You bet they would. Because words matter, titles matter, even though the rights presented or given are identical. Now, we used to have separate drinking fountains for blacks who had to ride at the back of the bus. Rosa Parks got rid of that. You know, the bus did get them to the same place as the other passengers, didn't it, whether you're in the front or in the back? And maybe the drinking fountain water was of the same quality, maybe, but I'm not all sure about that. But our country, more importantly, our Constitution, no longer tolerates these indignities. So as Justice Ginsburg said in that oral argument, a skim milk version of marriage in the form of civil union or domestic partnership, she implied, is the same as separate and unequal. And separate is inherently unequal. Now, the present challenge to Prop 8, based upon the Equal Protection Clause of the U.S. Constitution, of course, is now being considered by the U.S. Supreme Court. I won't predict the outcome, if that's a question. But the debate is sure to continue, even after the court tells us what the law is. The nature of the family will continue to evolve, but on this issue, marriage equality, I'm happy to say that attitudes are changing with light speed intensity, and a lot of that is due to the generation that is represented in this auditorium. Now, judges and lawyers know that change never comes quickly. The democratic legal process moves slowly, as it should, but it does come, it does move incrementally, step by step, measure by measure. And it doesn't come easily, as we have seen. I mean, there have been riots and so many other disruptions with respect to many, many rights. And we all know that all deliberate speed, you know, Brown versus Board of Education, for example, was much more deliberative than it was speedy. But the point is that things that seem self-evident now, that we take for granted and that are embodied in our constitutions, things like interracial marriage or interracial couples having the right to marry, these things were not always so, they weren't always commonly accepted. So what will appear self-evident, what will be commonly accepted throughout our states and nation a few years from now, or perhaps maybe even in a couple of months, only time will tell. So I conclude by the reminder of that constant struggle for equal justice under law, which is proudly proclaimed in stone above the facade of our United States Supreme Court. All of us, we, you, deserve nothing more, but we also deserve nothing less. Thank you.